daily list, item number 1 for pronouncement of judgment.
Petitioner is not here. Not interested. So, walk over. I'll just read your portion. Excuse me. On an overall analysis of the facts and circumstances of the law and the law in this regard, this court is of the considered opinion that the impugned order has been passed without any application of mind, and hence is deemed to have been arbitrarily done to the detriment of the petitioner's cause. This being the case, this court hereby finds the impugned order dated so and so and related appellate order dated so and so cannot stand the scrutiny of law. The same are accordingly set aside and quashed. The petitioner is, however, directed to file a fresh application for renewal of his firearms, and the licensing authority is to consider the same in accordance with law and related rules in the light of the observations made herein above. Needless to say, if the law of limitation applies to such proceedings, such period may be considered as condoned if so applicable. With the above noted direction, this petition is accordingly disposed of. Thank you.
All right.
Yes, fast. If there's any mentioning, do it fast. Don't. Those will start.
May it please your lordship. Your lordship, I beg to mention item number 13, your lordship. For the state respondent, the conducting counsel, Mr. SN, is not available today, your lordship. No objection, your lordship. 13,
Lordship, I am for National Highway. I am for National Highway.
What is a land acquisition matter?
Land
Yes,
acquisition.
your lordship. First appeal.
It's a
Appeal against the award
appeal against the award.
on pre-made by the state respondent, not objected to by appellant. Matters adjourned. List system up to 3 weeks.
Your lordship, a similar prayer of item number 12, your lordship.
Well,
Yes, your lordship, as per the last order, the state had to produce some records, your lordship. We're praying for some more time, your lordship.
on pre-made by the state respondent, matters adjourned. List system after 1
2
week,
weeks, your lordship.
2 weeks.
Obliged, lordship.
My lord. My lord, I beg to mention item number 8 and 9, my lord. Right, my lord, this is related, my lord. Matter pertains to ACP, my lord, where I have to file a reply to the additional affidavit. So a week's time.
What does the additional affidavit say?
Affidavit say that, my lord, the case was that they have not supplemented with any affidavit with regards to the bringing whether the ACP was granted to me or not. So they have brought certain documents, my lord.
What is your case?
My lord, my case is that I have not been granted with the financial upgradation, my lord.
Yes.
So it is, nothing was on the record they have brought now, my lord.
No, but you see, as far as grant of ACP is concerned,
My lord,
it's just a question of calculation.
my lord, that has,
If you have been in a certain post for if it is ACP for about 12 years or so,
my lord,
then it should be granted to you.
my lord,
If there is no promotional avenue,
avenues, my lord. So that should,
and similarly with MSCP, of course, that's a different thing. It's just a question of years. So where is the question of filing records and nothing is required?
my lord, that record, it has to be, whether here also one question, my lord, whether the 10-10-97, my lord, has given a judgment, my lord, that initial rank, that pay scale was not granted, my lord. If it is not granted, then accordingly,
Yes, that will affect the subsequent.
my lord, my lord. So that has to be replied on. My lord has granted a time.
On premier by petitioner, this is matter of 2 weeks. That's 8 and 9.
My lord.
Much obliged.
May it please Lordship. Lordship, I beg to mention item number 11, Lordship. Lordship, this matter has already been heard, Lordship. It's fixed for written synopsis, Lordship. So we require 10 days time, Lordship,
Year 4
for the petitioner.
on premier by petitioner, this is matter of 2 weeks.
Deeply obliged, Lordship.
My Lord, I beg to make a mention of item number 14. The Connaught Counsel, Mr. E.H. Khrawalang, is indisposed. My Lord, I pray if the matter can come after 2 weeks. I seek consent of the party.
14.
14.
Year
No
for,
objection.
year for petitioner
Yes, Your Lordship.
on pre-made by the state respondent, not objected to by petitioner. This is matter after 3 weeks.
Much.
Hello, Blind. Item number 2.
May it please Lordship. Lordship, here the accused persons was arrested on 30th June 2022. And in the meantime, Lordship, the accused person, the allegation against the accused person that he is the financer. Now the police filed a charge sheet, submitted a charge sheet, and along with the 12 witnesses to be examined in this case. Now almost going to be more than 1 year, 11 months. Only 4 witnesses examined, and 4 witnesses, nothing has come out against my accused persons, and no more witnesses are coming in this case. So there is a delay of 2 years almost. I mean, I have been in jail, and during this period, I lost my mother, I lost my sisters, I have one small kid, and this is the reason that there is only ground that I have come for this bail application on delay of almost 2 years. I've been in jail.
Yes.
And
Lordship, I may be allowed to seek instructions because, Lordship, this will be in the trial court, there have been 5 bail applications, Lordship.
This is a case involving, and it's an NDPS case.
Lordship,
This is a case is an NDPS case
Lordship.
involving commercial quantity.
commercial quantity.
Now the only consideration for the court, if bail is to be granted, is to look into section 37.
37. So I'm not on the
I've
37.
gone through the records.
Yes.
There is nothing to convince the court that you are innocent.
Lordship, only
You face trial.
no, I'm facing trial,
Let
Lordship.
the
But
trial-
only
Matter of 1 year.
the question is that how long I'll face the trial. Now the witnesses are not coming.
That is not for us to say. It's
The
for the
witnesses are not
trial court.
coming?
You impress upon the trial court to take up a matter.
Lordship, even suppose if I go for
You are
considerations,
involved in a very heinous crime.
Lordship,
Nothing.
heinous crime. But Lordship, suppose I'm a financer. Lordship, I'm a financer. If I'm a financer, there must be something on record to show that I'm a financer.
Prima facie evidence under section 27A is very clear against you.
27A.
And 29.
So Lordship, so far 27A is concerned, the Supreme Court, while granting the bail, in one of the judgment of reported 2022, it said, what are the elements required to come within the purview of under section 27A? 27A, so if I, Lordship, I cite the judgment.
And you have also filed a bail application before the trial court.
5 times,
I
Lordship.
fell.
Now, between the last order passed by the trial court and today, show me what fresh circumstances have come up, except for your plea of delay.
Delay is no witnesses are coming. No prosecuting
When was
witnesses are coming.
the last bail order was on?
Last bail order was filed
April.
28th of March 2024, Lordship.
24th. Because we have come here, the Lordship, 4 witnesses examined. The evidence of the witnesses are there. I could procure only 2 of the evidence. It shows that none of the witnesses said anything against the present accused persons. Even the other 2 depositions, if I place before this court,
Let the
there's
trial,
nothing
let
against.
the trial continue.
But,
This court will request the trial court to take up the matter.
But already gone to 2 years, Lordship.
No,
For that reason,
yes,
there is
yes,
a
doesn't matter.
Lordship. There is one of the judgment of Supreme Court passed recently. It says that a person was in custody for 1 year, 11 months. In that view of the Supreme Court said it is violation of Article 21 and granted the bail to these accused persons.
Depends on the facts and circumstances.
Facts, same commercial quantity only.
When the charge sheet has been filed, you will have to convince this court only on the issue of prima facie case.
Lordship, the prima facie case, I am not saying anything on the prima facie case.
Almost all the co-accused are against you, witnesses are against you.
Because there is a
CDR details are there.
to come out from this 37 is a very rigorous, where the bail is very difficult to get. So only the Supreme Court said in the case there is delay in trial, the court may grant the bail on the ground of delay only. There is the only ground I can get the bail. There is no other ground. If I press on section 37, definitely there is no bail.
Mr. Koshi, you go to Supreme Court.
No, see, only the question is that how long will be facing the trial? There is a 2 years gone.
Mr. Koshi, Learned Counsel for the petitioner, was submitted that the petitioner has been is in custody in connection with an NDPS case being. What's the number of the case?
Is the case cleared? PS case number 64, 6 of 2022.
No, the NDPS case.
NDPS 9.
Number 9 of 2022, Lordship.
NDPS
My
case
prayer.
number 9 of 2022, pending before the Learned Special Judge NDPS at where?
East Jaintia Hills, Lordship. Clear?
Clear. The only ground raised by the Learned Counsel for the petitioner is that the accused in question is in custody for almost 2 years, and the trial has not proceeded expeditiously, with only 4 out of the how many witnesses? 12. 4 out of 12 witnesses being examined. On this sole ground, the Learned Counsel has submitted that the petitioner may be enlarged on bail. Per contra, Ms. Njishila, Learned GA, Senior GA, has submitted that this is a very serious matter involving NDPS, involving the provisions of the NDPS Act, and taking into account Section 37 of the said Act, the NDPS Act 1985. The petitioner, rather the accused in question, has not been able to convince this court as to whether the embargo seen in Section 37 has been overcome. That is, whether there is any proof that the accused in question is not guilty of the alleged offence. This court, on consideration of the submission made and on perusal of the petition in hand, would agree with the Learned Senior GA that the offence involved are serious in nature, inasmuch as it involved seizure of contraband, a commercial quantity of contraband. What is the substance?
Substance is heroin.
Heroin, Lordship.
Contraband substance, namely heroin.
See, my case is that only come on the ground of delay only, and
Yes. I've already noted.
okay. Yes.
As to the question of delay, this being the case, on perusal of the this being the case, the court is convinced that the petitioner or the accused in question has not been able to convince this court that he is not guilty of the offence alleged prima facie. However, on the ground of delay, this court would also note that cases before the trial court are proceeding in their normal course. It would not be proper for this court to direct such trial court to single out any particular case for speedy disposal. Be that as it may, it is also incumbent upon the trial court to take up the cases before it and proceed with the trial expeditiously under the circumstances. It is therefore the request of this court that the trial court take up the matter expeditiously. Accordingly, in view of the above observation, this court is of the opinion that this petition is devoid of merit. Seems accordingly dismissed.
Much obliged, Lordship.
Item number 3.
This is a POXO case, my lord. Moving for bail, my lord. 3 applications have been rejected by the
May it please your lordship. Your lordship, this is a bail application, your lordship, filed by the petitioner for seeking of bail for the NDPS matter which is pending before the special judge, my lord. My lord, it is the prosecution case that the petitioner is the driver, my lord, and he was arrested on 13 January 2023, my lord, on recovery of ganja. The quantity of recovery is 803.253 kgs, my lord. My lord, the prosecution has cited 10 witnesses, my lord, out of 5 which has been examined, my lord. My lord, the presumption under section 37 of the NDPS Act, my lord, does not arise against the petitioner for the reason being, my lord. May I take your lordships to page number 268, my lord. 268 of PW1 deposition, my lord. 268, my lord, serial number 18, my lord.
Yes,
With due permission, your lordship, may I read?
please.
It is a fact that apart from testing only one packet, I did not conducted the preliminary test on the remaining packets of 134 packet and assume that they contain ganja, my lord. My lord, the seizure officer, my lord, who had seized and who had tested the contraband, assumed, my lord, all the packages contain contrabands. And further, my lord, in the seizure witness, that is PW1 himself, my lord, he in the preliminary test which was conducted, my lord, which is at page 64, my lord, of the complaint. May I take your lordships to page number 64, my lord? Yes, my lord. Exhibit 2, that is Exhibit 2, which is exhibit before the trial court, my lord. The preliminary test conducting using the field drug testing kit, a small portion of dried plant leafy material was taken in a test tube to which a few drops of region B1 was added. Thereafter, 25 drops of region B2 of drug testing kit was added and the solution was shaken for about 1 minute. Thereafter, another 25 drops of region B3 of the drug testing kit was added and again shaken for 2 minutes. The mixture thereafter was allowed to settle for around 3 minutes. There appeared a dark brown layer in a lower liquid mixture which indicate positive results of marijuana, cannabis, ganja. My lord, but my lord, in this exhibit 2, nor the name of the case is recorded, nor the accused name is recorded. The truck number from where the contraband was recovered, my lord, is not recorded.
See, miss, you're going to the nitty-gritty of the evidence. That would have to be considered and appreciated when the sum total of the evidence is looked into.
Yes, my lord.
That would be the duty of the trial court.
Yes, my lord. This submission was
How many
raised.
witnesses are there?
My lord, 10 witnesses, out of which 5, my lord. But this same.
How many accused persons are in this?
My lord, only one.
Only one.
Yes, my lord. And my lord, this submission which I'm raising before your lordship, I have raised the submissions in the trial court, my lord, but the trial court had failed to consider my submission during my bail application, my lord. My lord, and there was no sketch map prepared, my lord, at the point of interception, and the formalities of Waitman, Panchnama, everything which is annexed in the entire charge sheet, my lord, to implicate my accused person was prepared beforehand, my lord, in the DRI office. My lord, to prove the submission, my lord, I'd like to take your lordships to page... to page number 285, my lord. PW5, my lord. In serial number 10 of the examination, my lord. Independent witnesses, my lord. They are the independent witnesses. Page number 10, my lord. Page number 285, serial number 10, my lord. My lord, it is a fact that the entire documents were prepared by the DRI officers on 13/01/2023 at DRI office situated at Langkading, Mingi, and I was called by the DRI officers on 14/01/2023 to be present at the office and sign the documents annexed in the charge sheet. And my lord, even point number 7, the independent witness, it is also correct that the entire 135 packages, I did not see with my own eyes that they contain ganja. My lord, the question is here arises that how did they sign the seizure memo and everything, my lord, when they did not see the contraband with their own eyes? And all the documents, my lord, regarding even the preliminary test was already prepared beforehand by the DRI, my lord. Hence, my lord, the section 37 does not arise against the petitioner, my lord. And further, PW2 also, my lord.
What is the
PW2.
section as far as seizure is concerned? Is it 42 or 52 or 50?
Seizure memo.
Yes, Dr. Musiga, what is the
Seizure memo is of dated 14/01/2023, my lord, which is at page. Which is this is the Whitman sheet. Seizure page 66, my lord. Seizure memo, inventory of seizure goods.
yes?
And the next page is follows, my lord.
Yes, Dr. Musiga, I think this involves section 42.
My lord, section 42 will be established in trial. My lord, the contention of my friend, my lord, if lordship kindly comes to page 39, my lord. My lord, what a friend is referring to is a preliminary test, my lord. Now here we have the final FSL report, my lord.
But
I'll just complete the... Page 39, para 26.
Yes.
Just read one paragraph. That, Madam, the forensic examination report of the samples of ganja drawn before the magistrate was handed over by letter number so and so, along with the remnant exhibits, was received from the Director, Central Forensic Science Laboratory, Home Ministry so and so. The test report clearly indicates that the samples gave positive result for ganja cannabis. The remnants exhibits of one sealed cloth parcel and one sealed parcel are returned marked as so and so, so and so, so and so with the seal impression of CFSL, NAR, Kamrup was deposited with the submitted. And my lord will see.
the allegation is this. See, the allegation is this. Suppose out of 10 package of alleged contraband seized, sample was drawn from only one.
No, my lord, that is preliminary test, my lord.
Preliminary test, no doubt.
Preliminary test at the location, my lord.
Preliminary test at the location
My
to convince the seizure officers that it is really
My
ganja or any contraband
My
substance. That is true.
My lord.
But I think the law would say that all samples have to be taken from all the packages.
My lord, preliminary, there is no requirement for preliminary. Preliminary test, my lord, on highway when truck is intercepted, my lord, there are DRI people found 134 packets in the. So just from one sample, my lord, they come to know that this is ganja or not. If it suppose it is rice or something, then
Yes.
there is no question of doing anything. So that is only for preliminary test, my lord. Now the samples, the seized articles were produced before the magistrate, my lord. Court directed under section 52A of the NDPS Act for drawing of samples by magistrate. Magistrate drew the sample, lordship dealt with many matters. Samples were sent to FSL, my lord. That is the actual test, my lord. Preliminary test has no legal requirement, my lord. That is only on the highway, my lord.
Is there any evidence
My lord.
that samples have been drawn from all the?
Yes, my lord. The magistrate's order is there, my lord.
But my lord, there is.
I'll just complete, then you can just.
Let us. You are also privy to the records.
Yes, my lord.
It would be there in the charge sheet only.
Yes, my lord.
Para 21, my lord. Para 21.
Of
They have not annexed the order, my lord. I am only referring to para 21 of the page 36, my lord.
yes.
That, Madam, by letter of even number so and so, the Superintendent Disposal Customs Headquarters was intimated to make him available for verification of NDPS samples of case number so and so. And verification was carried out in the presence of Srimati K.E. Rimbai, JMFC Shillong on 26/23. After verification, Srimati K.E. Rimbai, JMFC Shillong passed the following order. The box containing the duplicate samples was opened in my presence. The duplicate samples were taken out from the box and 136 number of packets were found inside the box. Samples marked as 051 to 057 and 135 were found inside the box. Samples marked as D32 and D37 are not present in the box. It appears from the letter number so and so. dated so and so, issued by Director CFSL Assam, that the samples marked as D32 and D30 are in box containing the original samples which were sent for examination. The samples marked as O51, 57, O135 were kept inside another yellow envelope which was sealed in my presence and signed by me. IO shall take necessary steps in sending the packets marked as O51 to O57 and O135 to CFSL. The samples marked as D32 and D37 shall be brought back from CFSL, and in continuation of the exercise as directed to be conducted in my presence. IO to produce the box containing the duplicate samples and the samples marked as D32 and D37 after being brought from CFSL. Then that madam, samples marked as O51.
See, the query is this.
Madam.
What does the law provides for as far as collection of samples are concerned? Are samples to be taken from each and every container or package, or only from a few?
No, but samples must have been taken because the requirement, there is a SOP, my lord, for ganja, which says that if identical products are in several packets, my lord, some 5 grams or something has to be drawn out from every packet, homogeneously mixed.
You have that SOP with you?
But only charge sheet has been annexed, but the supporting documents have not been annexed, my lord. Yeah.
My lord, we have annexed all the entire complaint, my lord.
You may not have everything, but they will have everything with them.
My lord, page 33, lordship kindly comes, my lord.
Yes.
Page 33, the last paragraph, my lord. Further, as directed by the Special Judge NDPS East Kasihal District by the order dated 16/1/23, samples of 25 grams each, original and duplicate, were drawn from all the seized 135 packets of ganja in the presence of Srimati K. Rimbai, Honorable JMFC, the Superintendent Disposal Customs Headquarters, Godown, Shillong, and the IO of the case on 9/2/23. The samples so drawn were packed in plastic pouches and heat sealed, and each of the pouches were marked O01 to O135 and D01 to D135. The samples O01 to O135 were packed in a carton and marked as original samples, packet number so and so, and wax sealed and signed by learned JMFC and the IO of the case similarly. The duplicate samples marked D1 to D135 were packed in a carton and marked as duplicate samples, packet number so and so, and was wax sealed and signed by the learned JMFC and the IO of the instant case. The learned magistrate allowed original samples to be sent for chemical analysis. During the process of verification and drawal of samples, photographs were taken. The samples so drawn were handed over to the Superintendent Customs Disposal, white letter number so and so, for safe custody. So in my humble submission, my lord, but these are the usual procedure followed in every case, my lord.
I think this is clear.
My lord,
Excuse me.
my lord, my humble submission is that, my lord, on reading the entire complaint, my lord, you will see, my lord, at para number 19, my lord, that madam, a letter from the director CFSL by dated so and so and dated 12/06/2023 was received via mail, stating that the following discrepancies were observed on opening the seal cloth parcel having samples in a cartoon box of the case. Only 134 samples were found in the cartoon box, where 135 original samples were supposed to have been packed. Serial number marked O32 and O37 were found in duplicates, and serial number O51 and O57 and O-135 were not observed in the said cartoon. My lord, there were discrepancies also, my lord.
You see, Miss, like as I observed earlier, these are all matters of evidence, appreciation of evidence, which will be taken into account. You have a right to point out all these discrepancies at the time when the matter is finally argued. As far as bail is concerned, I don't see any connection. As far as if there's any discrepancies,
Yes,
collection of samples or testing of samples
And
All these things will not come.
And my lord, PW4 has also said that while signing the seizure witness, the annexures, my lord, he said that he has not even read the contents, and it is the DRI who
Yes,
stated that
those are all matter of evidence.
it is Genja, my lord, but he has never observed it with his own eyes. And even PW2, my lord, based on assumption, he said that all 135 packets are Genja. My lord, I will take you to my lord, page number 272, my lord, wherein PW2, who is another officer, my lord, 272, my lord, point number 5. It is a fact that I was just assuming that all 135 packages are Genja, and I did not observe it with my own eyes.
He may have said that, but the fact remains that what was read just now, that paragraph, page 33.
Yes,
What was
my lord.
read just now was that in the presence of the magistrate, all the 135 packets were produced.
Yes, my lord.
Samples duly taken from each. Whether they would match ganja or not, that's a different thing. But forensic report would say otherwise.
Yes, my lord. And my lord, but on the day of the siege of contraband, on the 13th of January 2023, my lord, the
Where is the
samples.
forensic report?
But my lord, the samples are not in dispute, my lord, but there is a 26 day of delay, my lord,
Anyway,
in sampling.
let us see the report. What does it say? Yes, Miss. Tell me.
Copy of. My lord, page 183. Forwarding of the forensic examination report and return of the remands exhibit.
Page 186, my lord. The result of examination.
Results of
The exhibits were analyzed by color test, thin layer chromatographic analysis, and gas chromatography, mass spectroscopy method. Characteristic microscopic features of cannabis were considered consistently observed. Chemical tests and chromatographic analysis gave positive test for cannabinoids and cannabidiol, including THC. The inference thus drawn is given below. Exhibit 1 to 135 are samples of ganja cannabis.
My lord, I'm not disputing the samplings, my lord. But the question here is a delay of 26 days, my lord. And my lord, in sampling, in the contrabands were in the godown, my lord. But then there was a delay of 26 days, my lord. He was arrested on 13 January.
All these issues can be agitated at the trial court.
My lord, I've made the submissions, my lord, before the trial court during considering the bail application, but my submissions were not considered, my lord.
You have not come here under by way of an appeal, have you?
No, my lord.
When was the last date fixed?
The last
Before the trial court?
Before the trial court, it was last month, my lord. It was on the 26th. 26th, my lord.
So you said 5 witnesses have been examined?
Yes, my lord. And my lord, the petitioner, he has a small child also, my lord, who is of 9 months, my lord. And his wife is also a homemaker, and he is the only one who's running after the family, my lord. Looking after his family, my lord. And as of now,
yes, we are dealing with a case under the NDPS Act.
Yes, my lord.
You also have to look into the gravity and nature of the alleged offence.
Yes, my lord.
If you are not saying that you are guilty.
Yes, my lord.
Until and unless the final verdicts come.
Yes.
But as far as the process and procedure is concerned.
Yes. But my lord, there is an unexplained delay of 26 days of sampling and everything, my lord. That also has to be taken into consideration. And to the fact that, my lord, the preliminary test, which was conducted only from one bag, and the rest of the bag, it was assumed to be contrabands, and the provisions of NDPS, my lord, does not.
That is why it is the observation of this court that all those issues will be looked into by the trial court at the right and proper time.
Yes, my lord.
What we can ensure now is for the evidence recording of evidence to proceed expeditiously.
Yes,
since when was the evidence recorded? When was the first witness examined?
My lord, the first witness was examined on the 22nd of November 2023, my lord.
Now, but then it's fine. 5 witnesses in a matter of 5 months, 6 months or so.
The charge sheet was filed in August 23, my lord.
My lord, then I'd like to withdraw this petition, my lord.
You take your chances before the trial court.
I will withdraw this petition, my lord. My prayer is
I would have dismissed your petition with a request to the trial court to expeditiously.
No, my lord, it's okay, my lord, but kindly I'll withdraw this petition. Kindly consider my
Learned counsel for the petitioner was submitted that you be allowed to withdraw the petition. On premium, seems allowed. Petition is hereby dismissed as withdrawn.
Highly obliged, my lord.
Item number 5.
Deeply.
Please, Lordship. Lordship, we have filed a written synopsis, Lordship. Dear Lordship.
Oh, you okay.
Lordship may reserve it for judgment, Lordship.
We have already
You have filed?
Yes, Your Lordship.
Learned counsel for the petitioner has submitted that the written synopsis of the argument advanced before this court has been filed by the petitioner. Ms. Learned counsel for the respondent has also submitted that the written argument on behalf of the respondent Lehu has also been filed. Accordingly, this matter is now posted for reserve for judgment.
6 and 7, Lordship.
6 and 7.
Item number 10.
Yes, is for Nokma dispute, my lord. So at all the times, my landed friend will do it.
May it please Your Lordship. Your Lordship, the counsel for respondent number 4 is on legs before court number 1, Your Lordship.
So end of the vote.
Item number 15.
Yes, Dr. Muzika.
My lord, as far as questioning the charges, I have argued on the last occasion, Lordship recollects, my lord.
You have argued?
Yes, my lord.
Now, who's to respond?
My lord, Mr. Khurshid would like to make his rejoinder submissions with respect to item 16. 15 is CBI's petition, which is yet to be argued.
But Dr. Muzika said he has already argued.
My lord, I have argued 16.
No, we are talking about 15 now.
My lord, 15 what happened, my lord, this is against the postponement of. My lord, in my humble submission, 16, 17, 18, 19, they are decided, my lord. If these matters are decided otherwise, my lord, the 15 will not be required to be argued.
So we leave 15 for the time being,
my lord,
and go to 16, 17.
16 is the main case, my lord.
16, 17, and 18.
18, 19 also.
I think this the petitioner has already was already heard, and I think
Mr. Khurshid has argued.
Mr. Khurshid would like to make rejoinder submissions. He's a little tired of.
Just a moment, miss. Have you argued this matter?
Yes, ma'am.
You have responded?
Yes, ma'am.
Okay.
On the last occasion, Lordship recollects, my lord.
Getting confused here because so many times, this matter has been.
My lord, Lordship, on last occasion, going through the charge sheet, I've read the order, my lord, of the trial court, and I refer to the charge sheet and the allegations there, my lord, that the accused person was present when all those things were done.
Okay. Yes, now I recall.
My lord. And then I've taken your Lordship to indicate that what was in the chits.
Yes.
And so many things were there, my lord. And though it was argued that there is no pattern, that all of them.
So your contention is prima facie, a case is made out against the petitioner, for which she has to stand trial.
My lord.
And charges to be framed. Charges have been framed?
Charges have been framed. No, trial is proceeding.
Okay.
So, my lord, in 16, Mr. Khurshid would like to make rejoinder submissions before we file our written arguments. And 17, we are yet to argue. My lord, may kindly give a date after first week of June. He'll be available after first week of June, my lord.
For 16 and 17?
16 and 17. 16 just to make rejoinder submissions, and 17 to begin our arguments.
18 and 19, my lord, we had partially argued, my lord. It is partially argued, my lord.
By whom? By you?
Yes,
you are for the petitioner there?
Yes, sir. 18 and 19, my lord, we are for the petitioner.
You have concluded your?
No, not concluded. We have started, my lord, not completed. Okay. This will conclude, my lord.
So as far as 16, 17 first, let me pass the order. 15, 16, 17. 15.
My lord, on last occasion also I proposed, my lord, that let 16 be decided, heard and decided, my lord. Because otherwise what is happening will become very confusing, my lord. Because councils are different, my lord.
Yes.
One day one council is not present for some reason or other, my lord. So the matter is just being through. If item number 16 is decided, 70% of the matter will decide, my lord. Whatever will be leftover things, my lord.
Because they are
16 is the main, my lord.
Because if I made to understand, they are all related, interrelated.
Or interrelated.
Because it's connected to the same transaction, same set of
Stand may
incidents.
be different, but my lord, the
Stand. That is pertinent.
True.
Because your stand and the other petitioner stand may be different.
Slightly different.
They may be at at some point of time you may find cross purposes present.
In trial, my lord. While acting, they're together, my lord.
Yeah, we don't know.
My lord.
15, how many? 2 weeks?
Well,
2 weeks?
Well, 2 weeks, anytime after first week of June.
3 weeks.
We are 1, 2, 3. After 3 weeks. On pre-made by parties, this is matter after 3 weeks.
Okay.
It took 15, 16, no? 17.
Madam, 15, they are the petitioner, and in 16, 17 is identical.
Yes. No, in 15, you are the respondent.
Well,
But as far as 17, 16, 17, betul? 15, 16, 17, that'll suffice. 3 weeks. Then now, Mr. Panthi, you're saying about 18, 19. Would you like to continue with your submission?
My lord, he wanted, but my learned senior, my lord, he is next in court.
Well, that's why what I pray, my lord. If 16 is decided first, my lord, that will clear the way for most of the cases.
So
17, 18, 19 is simply adjourned after 3 weeks.
17, 18, 19 on pre-made parties, list is matter after 3 weeks. 3 weeks.
Second call, item number 10.
Mr. Jarika, this matter has been heard?
No, my
previously?
lord.
Not yet.
Not yet.
Please.
Hi. May I please, Your Lordship? The case is regarding the joint Nokmaship dispute, my lord, in Rongrengiri, Akhingland in Williamnagar, East Garo Hill districts.
Impugn order is against the order of the CEM.
Yes.
Now we just have to see whether.
Order, but this impugn order has been passed without hearing us, my lord. Without hearing us. Simply because on 16 and 21 or 20, district council is over, expired. Then before
Yes,
hearing
Mr.
any
Dey.
matter, they have passed the order.
If it is as simple as he says.
No, my lord.
That you have,
My
you have
learned
been
senior never brings simple things to court, my lord. No, it's not so simple, my lord, what he has said.
So you mean to say that he says he has never been heard?
No, that contention is not correct.
No.
As per the order of this court, district council has decided the matter after recording the evidence, my lord.
Concurrent orders, my lord.
Both the concurrent order is in favor of the private respondent. Now they have to show, my lord.
Concurrent order by EM and CM.
Yes.
And the lordship is not, they have not even challenged the decision-making process. They have just come saying, send the matter for a civil suit to file a suit, which under the rules is barred.
No, it
Section
is
11.
other prayer also is there to satirize this impugn order, my lord. Then court will decide whether it will be remand back or it will set aside or it will, because our prayer for also civil suit, it is bar as per this one. But High Court has got a jurisdiction over the district council.
True. But
Yes.
as Mr. Jara, firstly, you say that you have not been heard,
Yes.
for which the principle of natural justice
Yes, in CM
has
court.
been violated.
Yes, my lord.
They would say otherwise. So they
16/10/2022, my lord. 20.
at the relevant time you'll have to go through the records then.
Yes.
My lord, just before my lord senior start, my lord, if my lord may kindly come to the prayer portion. What is before this honorable court to adjudicate, my lord, is to set aside the order passed by the CM and EM, and also to remand the matter to the civil case, civil court, my lord, which is barred by section 11 of the yeah, my lord.
See, the court will look into that. If relief is to be molded, it will do so.
But my lord, then my lord, the virus of the act has to be challenged, my lord.
Yes.
That has to be challenged. That is not under challenge, my lord.
Here is prayer also is there, as to why the instance shall not be referred back to the court of the learned judge, Garhwal District Council Court, for prepare the adjudication shown upon these things. And also prayer also is there, number 2. That is our prayer, my lord. Respondent shows as to why the impugned order dated 17/12/2019 passed by the executive member IC Land and Revenue GSSE Tura in appeal number 21 of 2018 and another ex parte order dated 16/10/2020 passed by the 6th executive GSADC Tura in GSADC Revenue appeal number 12 at respective shall not be set aside and quashed. We are coming for that.
That's all. Yes, Mr. D. Where is the prayer for to remand the matter to civil court? Nothing is said.
No, it's there, my lord. My lord may kindly come to prayer 3, my lord.
Yes, prayer 3.
Page 18, my lord.
Yes.
Just a minute. As to why the instant case shall not be referred back to the court of learned judge.
Oh. Oh, learned judge.
Yes, my lord. So CM and EM are, my lord, they are not the judges.
No, that is, I may waive this prayer, my lord. Only I am
not waive, he has to strike down, my lord.
No, prayer number 2 is there, my lord, to set aside this order.
So you see, Mr. You think about it carefully.
Yes.
If you want this prayer number 3 to be struck out,
yes,
it will be struck out. So as far as prayer for remand is concerned,
yes,
no prayer is made.
No prayer.
Prayer is here, my lord. Number 2.
Yes.
Page number
If you had made,
17.
If you had made a prayer for the matter to be remanded to the CEM or to the EM,
that is up to the court, my lord.
Perhaps.
No, my lord.
Yes.
It cannot be up to the court, my lord.
No.
You have to make a specific prayer.
Yes,
no,
my lord.
Here is a specific prayer.
First, you have to point out how the impugned order has prejudiced you.
Yes.
Number 2, whether proper procedure was followed.
Yes.
No.
Even as far as procedure is concerned, we fall back on the Doro Sangma case.
Yes.
So here, now here this I am challenging 2 orders, my lord, in 2019 and another is 20, to set aside and quash. This is my prayer. But it is up to the court whether the honorable court will be referred or it will set aside the order. If it is set aside, our purpose will be served.
Then who will become the Nokma? Aking cannot be left alone without Nokma.
No, that is this order I am challenging. I am continuing in as a Nokma, my lord.
No, my lord. Now he is saying he is continuing. Then if he is continuing, my lord, why he is agree with this order?
No, that because there is some reason that.
What is the reason, my lord? Let him explain.
No. Then it should be heard properly, my lord. It should be heard from the beginning. Then only court will understand. Because this matter in 2017, from 2038, my lord, this Raksan clan is continuing as a Nokma of the Akangri road. Suddenly what happened in 1996, my lord, they come and claiming that to make a joint nokma. So controversy started from 1996-97, my lord.
Evidence has been led
Yes, my lord.
before the EM.
Yes, EM and CM.
Even against
CM.
Okay.
No, it is okay. It is against me, it is okay.
So
That
after
is
evidence has been
taken in the court of EM, my lord.
appreciated,
Yes.
then we agree by that impugn
Order, then
you had filed an appeal for the CM.
CM. And CM have passed the order without hearing us.
Okay. Okay.
That is the case, my lord.
Start.
Ready, sir? Ready?
Yes,
Ready.
or we'll do next week.
It's up to you.
No, no, I can do it today itself. No, that is no problem. I am going to page number 21, my lord.
First, you tell me who are you?
No, I am the Nokma, my lord. I am the Nokma.
Page 21.
Nokma of?
Nokma of Rongrengri, Aking land.
Page 21, sir?
Yes.
Page 21 is the verification, my lord, in my...
No, wait.
Yes, so I was asking him who he is, so he has pointed to page
27, my lord. I will go. 21A, my lord.
27.
27, 21A.
21.
21A.
A.
Annex 1.
Annex 1.
21A is the High Court order, my lord.
Yes.
No, that is I am coming. I have filed the case, then there is some mistake, so we have withdrawn and with a liberty
That
to
has no
file
consequence.
fresh.
That has no
Then,
consequence.
yes, my lord.
My lord, in this case, page 21, my lord, he has filed a CRP. He has challenged the order of the CM and EM, my lord. Then we are objected. Then he has withdrawn the petition, seeking a liberty to file a writ, my lord. It was CRP they have filed, my lord.
Okay.
CRP is not maintainable, my lord.
No, that is as per the advice of the Chief Justice during that relevant time.
My lord, it has not been mentioned here, my lord.
But verbally installed, my lord. You file.
The court will never
So anyway, my lord, that is not the must. Now I am going to page number 38, my lord, type copy. Here, my lord, brief fact is that the Rongrek Grey Aking land 5610 was purchased by late Sana Sangma and late Jimra Sangma from late Jingnang Nokma of Rongreng Grey village at rupees 800 dated 8/1/1918.
You are reading page 38.
Yes, my lord, here. I am just telling, my lord, page number.
No, that is a wrong, I think. So
No. No, I am not reading from this thing, my lord, because that is the title page, my lord.
The name of the parties is written, my lord.
No, it is okay. That is your document. That is not our document. It is supplied by this district council only.
Yeah, so what is the relevance of this?
And they have erected the deep, my lord. They have purchased, then they are putting the boundary pillar, my lord. And it is in page number 39A, my lord.
Yes.
Shall I read, my lord? Sir, on 10/1/1918 under 809 Paragona, the land purchased by the Sana Nokma and Jimra Nokma of Rongrengri from Jingnang Nokma, and they have put the boundary of the land on 21 January 1918, and it is authorized them
Not
to
1918, it has to be 2018.
18.
1918,
No, no,
sir.
no, no, 18, my lord. 2018. It is authorized them to prepare boundary map of the land. So boundary map they have given. That is, our claimed people have purchased the land from one Zhengdang Shangma, my lord. And till that, we are continuing as a Nokma of the Rongrengri Akhing land, my lord. Now, another one I am going to the order passed, my lord, by the Deputy Commissioner during British time, my lord. It is in page number 43, my lord. Annexure 5. Yes, my lord. Type copy.
Yes.
15/5/87. We have continuing as a Nokma since 1918, my lord, till date. And in 87/88, application by my father to the district council to register my name, our name, as a Nokma, my lord. In page number 43, my lord.
Yes.
An application submitted by Sri Jenang Shangma dated 18/3/87 is received by me and perused. The existing Nokmas and Jenang Shangma and his wife Srimati Benis Marak, our parent minor, Nokma eligible of Rongrengri, stated that during their lifetime they are willing to register the Nokmaship to their heiress daughter Srimati Justina R. Marak and her husband, the heir son-in-law Sri Awan Momin, including themselves. So I have become Nokma since 18 March 1987, and before that our parent was the Nokma of the Rongrengri Akhing land, my lord. As per will of the existing Nokma, remaining daughter and their husband and the connected Sras are also unanimously agreed to include their harassed daughter and son-in-law as they have submitted the written document of this office. Under the circumstance, I appoint Sri Awan Momin and his wife Srimati Justina Arshangma as included Nokma Rongrengri along with existing Nokma with effect from 15 April 1887, my lord. Since then, we have been continuing as a Nokma or Rongrengri Akhing land, my lord. And that is the next page, my lord.
Yes.
Now I am coming to geological tree of the Nokmaship, my lord, page number 45.
Yes.
Here is Jenang Shangma, that is my parents, and Binis, my father, and Binis Marak, my mother, my lord. After that, this Justina Marak, the daughter of the Binis Marak, and her husband Aban Momin, is the last recorded Nokma of Rongrengri Akhing land.
Yes. Yes.
Then what happened, my lord? Then I am continuing in this as a Nokma of the Rongrengri Akhing land. Meanwhile, one Nepilson Shangma and others filed petition praying for appointment of Srimati Nerinjing R. Shangma, that is respondent number 4, and her husband Withing Marak, and registered White 82 Atho, and without hearing the parties, EM passed an order on 28/8/1997 and directed to register their name as Join Nokma, the petitioner being aggrieved, prefer an appeal before the CM.
You're reading from which?
Yes, that is page number. Judgment and order.
He's reading from the note, my lord. That note is not with us.
Which page, sir? Judgment and order.
Of?
2006, huh? 45. That the petitioner being aggrieved by the order.
What order?
That is CM order dated Atho, that is reflected in the, I am coming to Annex or 7, my lord.
Mr. Hajara, first you have led this court to page 46, 45.
Yes.
Yes, there.
45, yes.
Table.
After that, I have given the High Court order, my lord.
High Court order?
Yes.
What happened? Why you have gone to High Court?
Because we have agreed by the two orders, my lord, of the EM dated 22/8/1997 and
So
CM order.
Where's that order?
That order is, we have not enclosed, my lord.
Then?
My lord,
Then against this order, we have filed this writ petition, my lord. It was registered WPC number 340 SS of 2005, my lord. It is clearly mentioned in this order, my lord. In this order, my lord, coming to this operative part of this order, the order was...
The order of the EM.
Yes, EM and CM.
CM, where you have assailed in this writ petition.
Yes.
340.
Yes, my lord.
Do they have relevance as far as the present case is concerned?
Yes, yes.
They refer to the same, same land,
yes.
same marking.
Yes, same marking, my lord.
Then you should have annexed those orders. Then.
those papers are then very vital, then, my lord, if it is the same marking.
See, which means that there is a a double proceeding in the as far as the matter is concerned.
Yes, yes, sir.
It cannot be. It cannot be, my lord.
Okay,
it has to be either the private party was before the court.
Maybe the court has amended the matter. I don't know.
Agreed by these two order, the file this writ petition, my lord. And in the writ petition, I am coming to para 10, my lord.
See, Mr. Jarika, if you are referring to this order in the writ petition numbers 304, 340,
yes.
What is material here is only the operative portion, which says that the matter has been remanded to the EM for
my lord.
prejudice.
Yes, my lord.
So that remains there.
Yes, yes.
Now, when the matter came back to the EM, you must have considered the matter.
Yes.
So you go from there.
Yes. Thereafter, they have remanded back, my lord.
So the matter was taken up
by
the EM.
Yeah.
So where are those proceedings?
It's better to read the order, page 90.
This is the final impugn order, my lord. Challenge.
By the EM.
Yes.
Or that order is here.
Yes.
That is the impugn order, my lord.
But before, my lord, we go to the impugn order, my lord, the petitioner has to show that he is linked with the last registered Nokma, how he is linked, whether he is the daughter and son-in-law, or he is claiming that he is the Mahari of that last registered Nokma. Whether the last registered Nokma has a daughter or not, my lord. That nothing is mentioned, my lord.
It is here, my lord.
That table has been shown by you?
No.
Yes,
No,
it
my
is
lord.
there.
He is claiming that he is the father and mother of the last, the daughter and the husband of the last registered Nokma. But nothing in the pleading, my lord. My lord may kindly see each and every paragraph of the averment that they have made. Nothing is there. Suddenly he said that I am the son and daughter of so and so.
No, it is there, my lord.
Yeah, let's see, my lord. Let us see that para.
It is in
Because
which
his
para?
locus has to be first very clear here, my lord.
See, Mr. Day, let Mr. Hajarka finish his.
No, first, my lord, if that locus is proven, because we are hitting on the locus, my lord, maintainability of the petition. What is his locus, my lord, first? Let him prove his locus, my lord.
Then in that case, you file the petition. I will reply.
See, Mr. Day,
Yes. Number.
the fact that the impugn order has the fact that the impugn
Yes,
order
yes.
has indicated that he is the respondent.
GT is there. Para.
Yes, Mr. Please continue.
Yes. I am coming to that point, my lord. Huh? And yes. I am coming to my pleading, my lord. Page number 9, para 7, my lord. That the petitioner stated since 1918, the Raksham clan has been in exclusive possession and management of Rongtingri Aking number 4, 5610. It is pertinent to mention here that the late Jenang Shangma and his wife Benis Marak Nokma of Rongrengri during their lifetime filed an application before the EM IC Land and Revenue Tura registered the case number 71A/C of 1987 for registration of their heiress daughter. That means my parent are the.
You have referred to earlier. You have referred to this.
Yes, already referred, my lord. They are objecting that what is my locus, whether I am daughter of the last recorded Lokma or not, my lord. That order will be clear.
Yes, please continue.
Yes. Marak and her husband Sri Aban Momin, according to the executive member IC Land and Revenue Tura was pleased to pass an order 15/4/1987 appointed both the petitioner as a Nokma of Rongrengri Aking. Accordingly, GT and other relevant record were corrected.
You are reading?
That para 7, my lord.
Any
That it will come page number.
That is okay.
Yes.
Now, tell me what else.
Yes, I have got a locus because I am.
Fine. That we will decide later.
Yes.
But you go on with your case.
Yes.
With your submission.
Yes. Respect 5 and 6 page number. Annexure 5 and 6. So type copy in 43, my lord.
Yes.
Order pass here. As per application submitted by Sri Zenang Shangma.
That you have already read earlier.
Yes, my lord.
So,
that is because they are telling that yes, locus that is already over. No. 94, 96. Then I come to page number 85, my lord. That is remand back the case for fresh trial by EM.
Page 85.
And can accelerate page number 51. I will go. 51. May I please your lordship? I will go properly, so matter may become next week, my lord.
That is what I was telling from the beginning, my lord.
No.
It will take time.
Yes, it will take time.
This is the third round of litigation, my lord. For understanding of my learned senior, this is the third round of litigation before this honorable court. There was 2 round of litigation earlier, my lord, before they approached this honorable court.
3. Yes. It has been continued, my
You
lord.
have said so in the first instance, then why are you wasting the time of the court?
That's what, my lord.
It was remanded back, then evidence was met, then they lost, then they came back to High Court. High Court said, okay, fine, since you're not heard, send it back. After they were sent it back to the EM, they were heard, they were cross-examined. Thereafter, it was in our favor. Thereafter,
They filed an appeal.
An appeal is to, by way of appreciating whether the examination was done proper or not. Then again, the order was upheld. Now again they've come.
Yes. My lord, here the question, the very limited question is there, that once the EM record the evidence, my lord, and cross-examine, the witness has been cross-examined, examined and all, my lord, it is not required for the CEM again to, my lord, take the evidence, reappraise. There is no question. He is sitting as an appellate forum, my lord.
He can appreciate it.
But it should be hard.
No, my lord.
It should be hard.
Again, my lord, evidence cannot be laid down before this.
Evidence cannot be led.
Yes.
The evidence cannot be led, but he can appreciate.
Yes.
He has to appreciate it.
Yes.
Whether he may come to a different view.
Different view. Yes. He can appreciate, but cannot record.
Because they have not challenged the decision process, the decision-making process.
That is what you see. That is the cardinal principle of a judicial review.
Your Lordship.
Anyway,
You can't just come and say, oh, we were not heard.
No. That is impugn order passed against me. Against this order, we have come before this court because without hearing us, they have passed the order.
No, that is not correct.
Mr. H. Hajarka, counsel for the petitioner, who, after advancing argument, has candidly submitted before this court that he is not prepared to be heard in this matter today and has sought for accommodation. On premier receives a law. This is matter to 3 weeks.
Oh, bless you.
Will not buy of his own. क्या सर आप भी लंच करो जी सर हम जाने लगता है मेरा गर्लफ्रेंड खुला है सर अभी क्या है एक बात ये है वो भी करेक्ट करता है What is that?